fine. I can see the slides. Thank you. And thank you, everybody, for taking the time to attend this session. I think, for my part, I'm very pleased to be part of this group and start us working towards the fiesta that Bob mentioned. And obviously, this is via Zoom, so can't really read the room very well. But if I miss something, please do fire in a question via the chat or unmute, and I'm happy to try and address it. Or obviously we'll take questions in the scheduled Q&A at the end. I guess if we could move to the first substantive slide. So next slide, please. So I think there's a very, very short version of this conversation, which, if you look at the left-hand side of this slide, Hong Kong has not adopted the model law on enterprise group insolvency, the original cross-border insolvency model law, and we're not seriously looking at insolvency-related judgments. I think it's fair to say that there has been fairly consistent feedback from the specialist insolvency profession in Hong Kong to say that this is suboptimal, given Hong Kong's position as a sort of international hub for finance. That position has been reinforced by a number of judgments, which have stressed how it would be desirable if we had a legislative framework for recognition of cross-border insolvency. But nonetheless, the current position is that we have no implementation of the model law on a statutory basis. I guess more generally, the latest serious attempt to reform the Hong Kong insolvency and restructuring regime was still looking at a proposed procedure known as provisional supervision, which is, I guess, broadly speaking, similar to administration in other jurisdictions. But that proposal was originally floated at least 25 years ago, possibly a little bit longer, and we've still not got to a point of implemented legislation. So I think the idea of anything happening quickly from a legislative perspective is unlikely. What has happened, though, is the courts have filled the void. We are lucky in Hong Kong in that we have a number of experienced and quite pragmatic judges who have recognised, frankly, there is a need to deal with cross-border insolvency and provide a framework so that people can either get deals done or understand what the options are for recognition and how to structure liquidations. So what happened, and it's quite interesting, is the courts, when they originally stepped into this space, decided to build a common law recognition framework, if you like, and they did that somewhat tentatively. Actually, the early cases, the court made a point of making observations that if there is a continued lack of legislation being introduced in this area, then the court might need to rethink whether it's appropriate to continue to develop common law recognition. And what's fascinating actually is, as we have continued to fail to implement any legislation, the courts have almost done a 180 on their position And the courts are now saying that actually, because Hong Kong has completely failed to introduce legislation, it is different to other jurisdictions where this should be a matter for legislature. And actually, because our LegCo has failed to do anything, it is entirely appropriate for the courts to continue to develop the framework for common law recognition. So it's been a very interesting journey, but I think we're now in a position in Hong Kong where it's largely accepted that this is going to be a court common law driven process. It's going to be judge made law, and it's going to continue to develop without a clear statutory framework. Maybe I'll move on to the next slide. So I've attempted to synthesize over the next few slides what this regime looks like in Hong Kong. I would start with, I guess, a few general observations. I think the courts have made some important steps to try to standardize the process. For example, we do have now recommended forms of standardized orders. But it does remain quite unpredictable, and it is a fluid situation because we're still dealing with largely discretion. We have different judges with different levels of familiarity with the issues, and we don't have a specialized insolvency court here, so that can lead to slightly variable outcomes. But also, and probably more importantly, I think the cases that have come before the courts have driven the law to develop in certain directions. We'll come on to that in a little bit more detail. But I think where we have ended up is not dissimilar to the model law, in that you can get recognition if you are coming from a COMI jurisdiction. But I think you can also get recognition if you're coming from merely the jurisdiction of incorporation, even if it's not COMI. But the relief that you can obtain in those circumstances is likely to be limited. Again, not hugely dissimilar to a model law outcome. I think where we probably do differ is that certain relief, in particular the availability of a moratorium, may also depend upon the level of creditor support there is for the foreign process, and also whether there is a pre-existing winding up petition that's been filed in Hong Kong. I should also flag that we still have in Hong Kong the idea of an ancillary liquidation, and actually we might be seeing more of those going forward because the Hong Kong court is taking a hardened position on recognizing certain kinds of application for recognition from overseas. Okay, let's move on, and apologies, this is all very high level, but hopefully at least somewhat interesting to give you a sense of what's happening. I guess to try and understand why we're in this position, and I guess to try and predict the kind of relief that you'd be able to obtain in a certain case, it's helpful to take a step back and look at how and why the court developed, or the practice has developed in the way that it has. Um, Hong Kong has no corporate rescue regime. All we have at the moment is liquidation and schemes of arrangement. And a Hong Kong scheme does not impose any moratorium on creditor action. So it was quite hard to complete a restructuring where any minority aggrieved creditor could go and destabilize the process by filing a winding up petition. So the practice developed of using provisional liquidation for the purposes of rescue, actually quite similar to what was subsequently introduced in a number of the offshore jurisdictions through the light touch regime. That was quite often used in Hong Kong up until 2006, when we had a case called Legend, where the Court of Appeal, probably rightly, said that the introduction of a corporate rescue regime should be something for legislation. It shouldn't be something for the courts to introduce through the back door by allowing PLs to be used for novel purposes. And the upshot of that meant that you could no longer use a PL, or no longer have a PL appointed for the purposes of a rescue, which made it very hard to get a moratorium. Then the practice developed of using offshore as a means to get a moratorium in Hong Kong. So you would go and seek the appointment of provisional liquidators in the offshore jurisdiction where a Hong Kong listco would often be incorporated. And then the provisional liquidators would come back to Hong Kong, seek recognition, and then the Hong Kong court would grant that recognition and create a moratorium. Right? In one sense, it was horrible in that you actually have more options for a restructuring in Hong Kong if you're dealing with a foreign incorporated company than a Hong Kong incorporated one. But I guess it was an extremely useful tool that I think, broadly speaking, was welcomed by the market. Then over time, I think attitudes changed. There were a number of cases where Hong Kong court, at least, felt that the process was being abused. We were having provisional liquidators appointed purely to create a moratorium without really paying any attention to what is in the best interests of creditors. And I think probably driven by those cases, the court's taken a different approach now, where the latest position is we will recognise applications from the COMI jurisdiction, but if you're coming from jurisdiction of incorporation that isn't COMI, you might get recognition, but the relief that you'll obtain is going to be very carefully controlled. And I think that the court has indicated that it's either sort of managerial assistance, is I think the phrase that the court used, or carefully controlled and necessary further assistance. And then what we've seen actually more recently is actually very few applications being brought to Hong Kong for recognition, because the Hong Kong court is exercising a lot of discretion to not make winding up orders in Hong Kong. In some cases, even where there is little to no creditor support for a company's ongoing restructuring efforts. And so for that reason, if creditors aren't able to get a winding up in Hong Kong, and companies are confident that's not going to happen, actually you don't need to be making the application in the offshore jurisdiction to try and get a PL appointed and then come back and get the recognition in Hong Kong. So I think This is something that remains in a state of change, but I think I've accurately reflected the current position on ability to get recognition. I guess I'll just take one more minute. If we just move on to the next slide, I've tried to summarize what you can obtain when you get recognition. I think the first point is Hong Kong courts are actually quite clear that you should not need a formal recognition order to access information and documents that ought to be available to the management of the foreign company. There've been a number of cases where, in particular, banks have insisted on a foreign liquidator obtaining a formal recognition order before the bank will deliver account details. And the Hong Kong court is trying to make the point that that is not necessary. However, to go further than that, to actually start to deal with assets in Hong Kong, you do need a specific Hong Kong recognition order. In terms of moratorium, to say whether you get a moratorium now likely depends on whether you're COMI or just jurisdiction of incorporation, level of creditor support, and a number of other factors. But what is clear is any Hong Kong moratorium will only extend to prevent unsecured creditors taking action. There's no route to a moratorium against secured creditor action. And then the final thing I would flag is we are a GIBS jurisdiction. Any recognition in Hong Kong would not extend to allow a Hong Kong law debt to be compromised under any foreign regime. I'm conscious of time. The last thing I would do is just briefly mention that in addition to the common law recognition regime that I've mentioned, and if we could go on to the last slide, sorry, Shana, there is now a specific pilot scheme between Hong Kong and the PRC. What's interesting is the Hong Kong courts have given some quite clear guidance to say this may not, as a matter of Hong Kong law, only apply to the 3 pilot cities that are part of the memorandum of understanding. The Hong Kong courts have said, actually, if applications come in from other parts of China, then they should follow the same regime. And whether or not it's appropriate for applications to come in from other parts of China, that's a question of Chinese law for the Supreme People's Court. So I think the takeaways from this are it is a specific Hong Kong and China regime. It's largely untested, but also don't assume it's just limited to the 3 pilot cities. It might well have a wider application. So it's actually a far more material development that might be obvious on its face. And I think that was all I was going to say. I'm sorry, I've tried to cover quite a lot in 15 minutes. I think I've already used my question time, but hopefully that was at least a somewhat useful introduction to the Hong Kong situation.